subsection of the rules that we're about to dive into is client confidentiality. Client confidentiality will make up 6 to 12% of your total MPRE exam. The place that I like to start with client confidentiality and this subsection is to highlight the differences between the attorney-client privilege and this duty of confidentiality. Once I highlight those differences, then we're going to break apart this attorney-client privilege rule and then, of course, the duty of confidentiality. I think if you're comfortable with the differences and comfortable with the two rules, you will handle this subsection very well in all of those questions that are associated with it. So to start, let's talk about the summary of the differences between attorney-client privilege and this duty of confidentiality. So the attorney-client privilege is really an evidentiary rule that prevents a court from using its powers to compel the revelation of confidential communications between an attorney and a client. This is in contrast to this professional obligation or duty of confidentiality, which prohibits an attorney from voluntarily revealing information relating to the representation of a client. Additionally, the attorney-client privilege protects only confidential communications versus this duty of confidentiality, which covers confidential communications and any other information that relates to the client's representation. Finally, the attorney-client privilege only prohibits disclosure of information. The duty of confidentiality not only prohibits the disclosure of information, but also prohibits attorneys from using it against or to the disadvantage of a client. So now that we know the differences, let's talk about the attorney-client privilege and the rules specifically before we break it down. So the rule for attorney-client privilege states that this is an evidentiary rule that prevents a court or other governmental entity from using its powers to compel the revelation of confidential communications between an attorney and a client or the agents of either the attorney and the client. So let's break down some of those terms that we used in that rule statement. First things first, attorney. To define attorney in the context of this rule, that means anyone that is authorized or who the client reasonably believes is authorized to practice law in that jurisdiction. The attorney must be acting as an attorney when the communication is made, rather than as a friend or as a business partner. Client. This definition also includes prospective clients. So this is anyone who seeks legal advice or services from an attorney, even if the attorney-client relationship is never actually established. When it comes to corporate clients, who is technically the client, or who does this rule cover? Here the definition states, if the client is a corporate entity, any communications between high-ranking officials, for instance like CEOs or CFOs, and the lawyer will be considered covered by the attorney-client privilege. Further, any communications by an employee and the lawyer will be covered, so long as the employee is communicating at the direction of the employee's superior. The employee knows that the purpose is to obtain legal advice for the corporation, and finally, the communication concerns a subject within the scope of that employee's duties to act on behalf of the corporation. So in other words, client here can also encompass lower ranking people within a corporation as well for the purposes of attorney-client privilege. What does communication mean in the context of this rule? Communication means information that is passed from the client to the attorney, or again, agents of either the client or the attorney. When we use the word confidential in the context of this rule, this means it is something that the person reasonably believed no outsider would hear. A statement is not considered confidential if a third party who does not reasonably need to be present is and becomes involved or part of the conversation. So to give you a few examples, if a client brought her accountant to a meeting and an attorney had a legal secretary present to take notes and an interpreter to interpret the client's foreign language, confidentiality isn't destroyed. So while there are third parties present, like the legal secretary and the interpreter or the accountant, so long as those people were necessary for that type of communication, then confidentiality is not destroyed. However, if a client has a discussion in a coffee shop where other customers can easily hear the conversation, then there would be no privilege here. So now that we know what the attorney-client privilege is, what is not covered by privilege? And there's a few things that are not covered. The first is generally the identity of your client and the fee agreement that's been reached between the lawyer and the client are not covered, absent exceptional circumstances. And I think this makes sense. Your client's name is not protected. We disclose client names when it comes to doing conflict of interest checks, so there's really nothing too private here. Additionally, fee agreements can't be protected because we have rules regarding and regulating lawyers' fee agreements that they reach with clients. If those were protected, there would be no way to regulate lawyers in that regard. Additionally, pre-existing documents and evidence are not covered by the attorney-client privilege, and I would like to give you an example on this. So let's say a client comes into the attorney's office and says, "I just stabbed my boyfriend with this knife, and I killed him." The communication would be privileged between the client and that lawyer. The attorney should not take the knife. If the attorney does take that knife, he must turn it over to the authorities. The attorney can tell the client to put it back where it was. The attorney cannot advise the client to destroy the evidence. But again, just to be clear, the communication between the lawyer and the client would be protected here under privilege, but the knife or the evidence or the weapon that led to the killing of the boyfriend would not be protected. It's also good to remember that the client holds the privilege here, meaning that the client has the ability to waive the attorney-client privilege if they so choose. The lawyer does, though, have a duty to invoke privilege on behalf of the client if the client is not there to claim it themselves. And please remember that this privilege lasts forever. It survives the termination of the attorney-client relationship, and it also survives death, meaning even if the client dies, the lawyer needs to be sure to keep those types of confidential communications privileged and not disclose them. So now that is the rule for attorney-client privilege. But there are some exceptions that you should be familiar with. Specifically, there are 4 exceptions to privilege, and we will take each one up in turn. First, the first exception states, it does not apply if the client is seeking the attorney's services to engage in or to assist a future crime or fraud. So let's say if a client sits down in the lawyer's office and tells the lawyer that he needs help lying on a business loan application, this communication would not be privileged. The second exception to privilege is that it does not apply to a communication that is relevant to an issue of breach by either the attorney or the client of duties arising out of the attorney-client relationship. So again, to give you an example here, let's say the client is months behind paying the lawyer for her past services relating to its divorce. The lawyer can file a lawsuit against the client to recover these past due legal fees. The lawyer is also able to divulge statements made by the client relating to its lack of payment. For instance, conversations between the two regarding this payment and their payment arrangement. However, the lawyer cannot reveal information about the client's divorce that would be unrelated to the issue of back due payment for legal services. The third exception to privilege is that privilege does not apply in civil litigation between two persons who are formerly joint clients of the attorney. This is the trickiest one for most people, so again, to give you another example here. Let's say a lawyer represents clients A and B in a business transaction. Later, A sues B regarding the previous business deal. Neither A nor B can claim privilege to prevent either party from repeating things said between the lawyer, A, and B in that previous transaction. But please note that the lawyer should tell them that their communications are not privileged and should basically explain the risks associated with joint representation should a dispute occur. I think it's helpful to think of this exception as basically the rules regarding privilege treat joint clients like one person. So using that example, the lawyer represented A and B jointly, and basically the outcome was that the parties could not assert privilege as it relates to communications that they had with the lawyer. And this is because the rule basically views them as one client and you cannot assert this privilege against yourself. So that's why this exception essentially exists. And the fourth exception to the attorney-client privilege is that it does not apply when the attorney can furnish evidence about the competency or the intention of a client who gives or attempts to give property by will or during life. So again, to give you an example here, let's say a client has a lawyer draft a will, leaving all of her property to one of her 2 children. the client brings the lawyer a list of reasons why she's disinheriting one of her children. Upon the client's death, the disinherited child contests the will. Lawyer is allowed to furnish evidence of the client's capacity and the wish to disinherit that child. So that wraps up the attorney-client privilege. Let's next move on to this duty of confidentiality that we know is testable from this subsection of the rules. So here the general rule is that a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent or the disclosure is impliedly authorized in order to carry out that representation, or the disclosure is permitted pursuant to one of the exceptions. The duty of confidentiality, or in other words, this confidentiality rule, not only applies to matters communicated in confidence by the client to the lawyer, but it also applies to all information that relates to the representation of the client, regardless or whatever its source may be. So I think it's very helpful when you compare and contrast the attorney-client privilege to be sure that you understand that the duty of confidentiality in comparison to privilege is much broader, because the duty of confidentiality not only includes or encompasses those confidential communications between a lawyer and a client, but it also pertains to all information relating to the representation regardless of its source. So to give you a quick example, if you are representing a client in a personal injury action and the client comes into your office for a private meeting and you guys are discussing your client's injuries, that conversation would be protected according to privilege. That would also fall under your duty of confidentiality, meaning you should not divulge that information unless you have consent or unless you're impliedly authorized or unless some sort of exception exists. But to give you kind of a different example of when the duty of confidentiality would kick in, let's say you're representing that same client in the personal injury action, and you get your client's consent to obtain their medical records so that you can look over them and build your case moving forward in their personal injury action. Well, once you obtain all of their medical records, you're going to go over those records on your own, or you're going to have your legal secretary or your clerk or your paralegal help you summarize them and go through them. The reason I'm saying that is because your client is not going to come into your office to read you all of their medical records. And the good news is your client doesn't have to do that. All of that information that you learn about your client in their medical records is going to be protected under the duty of confidentiality. Why? Because it's information that you learn regarding your client throughout the representation of that client, regardless of its source. So it doesn't matter that you're learning this information from a medical record, it's still protected or covered under confidentiality. So again, this duty of confidentiality, when you compare it to privilege, is much broader. It encompasses more. So let's break down this duty of confidentiality a little bit more. The duty of confidentiality lasts forever. It continues beyond the termination of the lawyer-client relationship, and it even survives death, much like privilege. Next, let's break down the times in which you can disclose confidential information, because the rule says you shall not disclose confidential information unless you have your client's consent, or unless you're impliedly authorized, or unless an exception exists. So first things first, let's talk about getting your client's consent. The obvious piece here is if your client expressly consents to your using of their confidential information. And in my opinion, this is rather straightforward and likely not something that you will encounter on the MPRE. But if a client expressly authorizes an attorney to reveal information by way of informed consent, then the attorney can use it and can disclose it, and they will have no ethical issues as a result. So that's express consent. Let's talk about that implied authorization, because I told you that you can disclose confidential information if you're impliedly authorized. It's good to know that implied authorization exists in two circumstances. So let's break that down. The first is that a lawyer is impliedly authorized to make disclosures about a client when appropriate in carrying out the representation of that client. This is, of course, unless the client's instructions or special instructions or circumstances has limited that authority. So to give you a quick example on this, let's say, for example, a lawyer is representing a client, say, in a divorce action. Here, the lawyer would be impliedly authorized to admit a fact that they cannot properly dispute, or to make some sort of disclosure that facilitates a satisfactory conclusion to a matter. So let's say that while you're representing your client in a divorce action, you could admit that your client makes $500 a month selling candles on the website Etsy. This is true, even if that type of admittance of a fact or that type of disclosure reduces the alimony that your client would receive. This is an honest disclosure, and it's necessary to resolve some sort of support or alimony dispute. And additionally, it would be hard to avoid that type of disclosure because that type of information would show up on your client's taxes. So that's the first scenario in which you're impliedly authorized, when it's necessary for you to carry out the representation of your client. The second scenario in which you're impliedly authorized is that lawyers in a law firm, in the course of their firm practice, is allowed to disclose to one another information that relates to the clients of the firm. This is, of course, unless the client has instructed that particular information be confined to specific lawyers. The way I think of this implied authorization rule is that when someone hires a lawyer at a law firm to represent them in their legal issue, there's also this assumption that other lawyers and other people at that firm are going to be handling and helping out on that matter. And I would go so far as to say that, if you hired a very large law firm to handle your legal matter, a lot of people are interested and find large law firms attractive because of how many lawyers work there and how high-powered they are. Those lawyers have each other to lean on and to get help and to bounce ideas off of when representing clients. So it's obvious, or rather implied, that lawyers are going to lean on one another in a law firm to get help while representing clients. And this is allowed unless, of course, the client has limited information or instructed the lawyer to not share information with certain people. So now we know, under this duty of confidentiality, that you shall not be disclosing confidential information unless you have express consent or unless you're impliedly authorized. And we've covered those two. Let's talk about the third piece of this rule. You're allowed to disclose confidential information if one of the 6 exceptions to confidentiality exists. So much like I said under the privilege rule, you should be very familiar with these 6 exceptions. The more familiar you are, the easier these questions are going to be. So let's talk about those exceptions. The first exception, it says a lawyer may reveal information relating to the representation of a client to the extent that the lawyer reasonably believes is necessary to prevent reasonably certain death or substantial bodily harm. So let's stop there. That is the first exception. The thing I like to point out is that for all of these exceptions, this is permissive. The rule uses the word may, not must. Meaning you may divulge client confidences in these circumstances, but you don't have to. And again, that first one being to prevent reasonably certain death or substantial bodily harm, but you do not have to divulge information. The second exception is to prevent your client from committing a crime or a fraud that's reasonably certain to result in some sort of substantial injury to the financial interests or property of another, and in furtherance of which the client has used or is using your services. So again, I'll stop there. The second exception does not speak to a million different sets of circumstances. A lot of people are confused by this second exception. If you are going to use this crime fraud exception, be sure that the client in your fact pattern has actually used the lawyer's services to commit the crime or fraud. That is key. So if the lawyer comes to know that the client has committed a crime or fraud, but that the client hasn't used the lawyer's services to do that, this exception does not allow the lawyer to divulge that information. The third exception to confidentiality says that you can divulge information if you want to secure legal advice about the lawyer's compliance with these rules. However, lawyers need to be careful here that when they get advice about whether or not they're in compliance with these rules, they need to be sure that they're not identifying their client. They need to be sure that they're being careful about that. The fourth exception is they can reveal or divulge information to establish a claim or a defense on behalf of the lawyer in a controversy between the lawyer and the client to establish a defense to a criminal charge or a civil claim against the lawyer based upon conduct in which the client was involved, or to respond to allegations in any proceeding concerning the lawyer's representation of a client. To stop there again, to give you some more insight on this, the way I think of this exception is that if you as a lawyer find yourself in some hot water or trouble in connection with your representation of a client, you do not have to wait until you've been sued or until you've been charged with something to protect yourself. We call this preemptive self-defense. So if you get in some trouble or hot water, or you see that you're about to get in some trouble or hot water in connection with the client's case or in a matter that you helped out a client with, you are allowed to divulge whatever information as is necessary for your own defense or to clear your name. And again, you do not have to wait until you're, sued or in cuffs in the back of a police car to be able to exercise this exception. The fifth exception to confidentiality is that you can reveal information under this rule to comply with law or court order. So again, to stop there and give you some more insight, the rules say that absent informed consent of the client to do otherwise, the lawyer should assert on behalf of the client all non-frivolous claims that the order is not authorized by law or that the information sought is protected against disclosure by the attorney-client privilege or some other applicable law. In the event of receiving some sort of adverse ruling, the lawyer must consult with the client about the possibility of an appeal. Unless an appeal or review is sought, however, this exception permits the lawyer to comply with the court's order. So in a nutshell, if you're in court and the judge has ordered you to divulge information that you know your client would not be happy about and that you know falls under this duty of confidentiality, what this is saying is you should first try to avoid that order by asserting every and all non-frivolous types of arguments you can. If that doesn't work and you lose and the court orders you to divulge this information, first consult with your client, explain to them your obligations, explain to them the possibility of an appeal. If they do not want to move forward with an appeal, you are allowed to comply with the court order and then divulge that information. And then the sixth exception to confidentiality is all about conflicts of interest. So here this exception says that you can divulge information to detect and resolve conflicts of interest arising from the lawyer's change of employment or from changes in the composition or ownership of a law firm, but only if the revealed information would not compromise the attorney-client privilege or otherwise prejudice a client. So again, to give you more insight here, the rules state that when a lawyer is considering associating with another firm, or let's say two or more firms are considering some sort of merger, or maybe a lawyer is considering the purchase of someone else's law practice, usually information has to be shared in order to try to detect and resolve any sort of possible conflicts of interest. So the information that should be shared or disclosed in an attempt to detect and resolve conflicts of interest should include no more than the identity of the clients involved or the entities involved in the matter, a brief summary of the general legal issues involved, and information as to whether or not the legal issue has terminated or is ongoing. But even then, under these limited circumstances, this information should be disclosed only to the extent reasonably necessary, again, to detect and to resolve these conflicts of interest that could result from these types of relationships that are changing and growing. So again, as little information as is possible to accomplish this task. So again, to wrap up this section, my focus here would be on the rule regarding attorney-client privilege, its exceptions, and then the rule regarding confidentiality and its exceptions. Be sure that you understand the differences between the two, and I think you're in great shape for this subsection of the rules.